Greetings to everyone. Hope everyone is in pink of their health. This side Suyash Tripathi. I'm a second year student pursuing BLLB honors from MIT Law School, Gwalior, Madhya Pradesh, and currently I'm working as a legal intern with LEXIS and Company. So today we are going to discuss the conditions for the Hindu marriage and the ceremonies of the Hindu marriage with restitution of conjugal rights. We'll cover these three sections. So the conditions for the Hindu marriage: a marriage may be solemnized. It is given under Section 5 of Hindu Marriage Act 1955. A marriage may be solemnized between any two Hindus if the following condition of neither party has a spouse living at the time of the marriage. So both the husband or the wife should not be having the living spouse at the time of the marriage. At the time of the marriage, neither party is incapable of giving a valid consent as it is unsound. So if a person is mad, then he cannot be said that he has given the consent by his own, as he was not he was not at that stage that he could give a free consent. Then though capable of giving a valid consent, has been suffering from mental disorder of such kind to such extent unfit for marriage and procreation of children. So though he is fit to give the valid consent, but he is suffering from such disease or such mental disorder that he could not procreate the child or can consummate the marriage or can enter into this marital relationship with his or her spouse, has been subject to recurrent attacks of insanity. Because if a person is suffering from the attacks of insanity, then this might be problem, as his or her spouse may be in danger, as the person can attack on him. Then the bridegroom has completed the age of 21 years and the bride the age of 18 years. So this is the age that before 21 years the boy can't marry, and before 18 years the girl can't marry. The parties are not within the degrees of prohibited relationship. So they should not be degrees within the degree of prohibited relationship unless the custom or usage governing each of them permits of the marriage between the law. So the prohibited relationship as defined in the section 2. Yeah, section 2. So Section 3. So the prohibited relationship is defined in the Section 3 of Hindu Marriage Act, that the relationship between the uncle and the niece, nephew and aunt, the Sapendas relationship that fall within the degree of prohibited relationship. So the marriage cannot be solemnized within the degree of the prohibited relationship. The parties are not the sapendas of each other. Okay, so the sapenda means the lineal ascendant, the generation lineal ascendant for the mother's side, and the fifth generation lineal ascendant, 5 generations of lineal ascendants from the father's side. So that the party should not fall under the sapenda relationship. Then we will discuss ceremonies for Hindu marriage. So a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto, where such rites and ceremonies include the saptapadi. Saptapadi, what is the meaning of saptapadi? Saptapadi means taking seven steps by the bridegroom and the bride jointly before the sacred fire. So we have seen that the bride and the bridegroom move around the fire and to take the 7 steps, or the move around the fire consecutively for the 7 times. So that is called the saptapadi. So if the marriage contains the ceremony of saptapadi, so after the 7th step the marriage has been said to be completed or solemnized. Now what is restitution of conjugal rights? So when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by the petition to the district court for the restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. So this means that if the person is not has withdrawn from the society of the spouse, for example, if the husband has left his wife for consecutively for the 7 years or for more than that, or 2 years, just for example I'm saying 7 years. So if he has withdrawn from her society, then the wife can file a petition for the restitution of conjugal rights, and the court on satisfying on being satisfied that the reasons or the grounds on which the husband has left the wife are not valid or are not right, so the court can pass the decree of restitution of conjugal rights. But if the husband says that that he has left his wife or have withdrawn from the society of the from his or her spouse, then the court may on then the burden of proof will lie on the husband or any of the party who is filing the petition for the restitution of conjugal rights. And if the court satisfies, then the court can pass a degree of restitution of conjugal rights, otherwise not. So thank you, that's all for today. And if you like my video, do comment in the comment box. Don't forget to press the bell icon, click on the subscription button. Thank you.